Welcome to the session 2 of Indian Patent Agent Examination video series by Pathways Consulting Solutions. Today we'll look at the history and origin of the Indian Patent Act. The first legislation in India relating to the patents was the Act 6 of 1856. The objective of this legislation was to encourage inventions of new and useful manufacturers and to induce inventors to disclose secrets of their invention. The Act was subsequently repealed and fresh legislation for granting exclusive privileges was introduced in 1859 as Act 15 of 1859. Further, in 1872, the Act of 1859 was consolidated to provide protection relating to designs. It was renamed as the Patents and Design Protection Act under Act 13 of 1872. The Indian Patents and Design Act 1911, Act 2 of 1911 replaced all the previous acts. This act brought patent administration under the management of Controller of Patents for the first time. In 1945, an amendment was made to provide for filing of provisional specification and submission of complete specification within 9 months to help inventions to be protected at the conceptual stage. After independence, it was felt that the Indian Patents and Design Act of 1911 was not fulfilling its objective. It was found desirable to have a comprehensive patent law that reflects to the substantial changes in the political and economic situation in the country. Accordingly, the Government of India constituted a committee under the chairmanship of Justice Dr. Bakshi Tek Chand to evaluate and report on the working of the patent system in India. The committee was also asked to examine the existing patent legislation in India and to make recommendations for improving it, particularly with the notion of prevention of abuse of patent rights. It was also asked to consider whether other special restrictions should be imposed on patents regarding food and medicines. The committee was also requested to generally suggest that those recommendations for enabling the Indian patent system to be more conducive to national interest by encouraging invention and the commercial development and use of inventions. However, the government did not press for the consideration of the bill and the bill was allowed to lapse. Furthermore, in 1957, the Government of India appointed Justice N. Rajagopala Iyengar Committee to examine the question of revision of the patent law and advise government accordingly. Based on the consolidated recommendations, the Indian Patent Act 1970 was passed, replacing all the previous acts. While the Indian patent system was evolving in India, the international system of protecting IPR was also subsequently evolving. First of it is in 1883 the Paris Convention. The Paris Convention is for the protection of industrial property. The international agreement is the first major step taken to help creators ensure that their intellectual works are protected in other countries. Followed by the Paris Convention was the 1886 Berne Convention. The Berne Convention is the parent treaty that protects copyrights for creators. The aim is to give creators the right to control and receive payment for their creative work on an international level. Works protected under the Berne Convention include novels, stories, poetries, plays, drawings and any literary and dramatic work. Further to 1886 Berne Convention, in 1891 the Madrid Agreement was passed. The adoption of the Madrid Agreement facilitated the international filing of trademark. Until today, the Madrid Agreement protocol is what is followed for international filing of brand names and trademarks. Followed by 1891 Madrid Agreement is the 1893 BIR-PI established. The Berne and the Paris Conventions together combined to form the predecessor of the WIPO's agreement called as United International Bureau for the Protection of Intellectual Property. In 1970, the United International Bureau for Protection of Intellectual Property establishes to become the WIPO, World Intellectual Property Organization. Further, in 1974, World Intellectual Property Organization joins the United Nations. WIPO joins the UN family of organization, becoming a specialized agency of the UN. All member states of the UN are entitled, though not obliged, to become members of the specialized agencies. Further, in 1978, under the WIPO, the PCT International Patent Filing System begins its operation. The PCT expands rapidly to become WIPO's largest international IP filing system today. The TRIPS Agreement, Trade-Related Intellectual Property Agreement under the WIPO system, is to date the most comprehensive multilateral agreement on intellectual property protection between countries. India became a member of the TRIPS Agreement, which came into force on 1st January 1995. The areas of IP that are protected under the TRIPS Agreement include copyrights, trademarks, geographical indications, industrial designs, patents, integrated circuits, and trade secrets. The three main features of the TRIPS Agreement are standards, wherein every country that is a signatory to the TRIPS Agreement should have certain set of protection, such as patent should be granted to all products and services. Secondly, patent should have a term of 20 years or the like. Apart from standards, enforcement. It is to be noted that any country that is a signatory to the TRIPS agreement should be facilitating means and methods of enforcing a citizen's intellectual property rights. The same amount of enforcement should also be available to any other citizen of other country who are also signatory to the TRIPS agreement. The third important aspect of the TRIPS agreement include dispute settlement. There has to be a third-party arbitrary means wherein any disputes on IPR between organizations or between countries have to be settled. The Indian Patent Act 1970, after the signing of TRIPS agreement. The Indian Patent Act remained in force for about 24 years without any change till December of 1994. The Indian Patent Act of 1970 did not grant product patents for drugs, pharmaceuticals and agrochemicals. An ordinance was passed subsequently after December of 1994 which effects certain changes in the Act post India signing the TRIPS agreement. This ordinance was replaced by the Patents Amendment Act of 1999. The amended act provided for filing of applications for product patents in the areas of drugs, pharmaceuticals and agrochemicals, though such patents were not allowed. However, such applications were to be examined only after December of 2004. Meanwhile, the applicants could be allowed an exclusive marketing right called as the EMR to sell or distribute these products in India subject to fulfillment of certain conditions. Post the 1999 Amendment Act, the second amendment to the Indian Patent Act was in the year 2002. The same year, the new patent rules of 2003 was also replaced. Earlier, the patent rules of 1972. The third amendment to the Patent Act was in the year January 2005. The ordinance was replaced by the Patent Amendment Act 2005, which was brought into force from 1st January 2005. The Indian Patent Office establishment and jurisdiction. The Indian Patent Office works from different locations within India. Each of these locations have their territorial jurisdictions. For example, the Patent Office of Mumbai is the territorial jurisdiction for the states of Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh and the Union Territories of Daman and Diu, Dadra and Nagar Haveli. Similarly, the Patent Office of Chennai has the territorial jurisdiction for the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana and the Union Territories of Pondicherry and Lakshadweep. Similarly, the Patent Office of New Delhi has the territorial jurisdiction for the states of Haryana, Himachal Pradesh, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, Delhi and the Union Territory of Chandigarh, Jammu Kashmir and Ladakh. The Patent Office of Kolkata has the territorial jurisdiction for the rest of India. Apart from these, each of these patent offices also have administrations such as the Patent Office of Mumbai, Chennai, Delhi and Kolkata processes the patent application. Design applications are processed by the Patent Office Kolkata. Trademark applications are subsequently processed by individual Mumbai, Chennai, Delhi and Kolkata Patent Office. Copyrights have been governed under the Patent Office of Delhi. Types of patent application. The most important two types of patent application are a provisional application or a complete application. First is a provisional application, an application which can be filed if the invention is still under the experimental stage or a conceptual stage. Provisional application gives the inventor an ability to file the patent application first and 12 months of time to complete his invention and file the complete application. Ordinary application. An ordinary application is an application which is first filed in India without claiming any priority application, which means it is the first application filed in India wherein a similar application is not filed in any other country. A convention application. An application filed in the patent office claiming a previously filed priority application in some other country, and a convention application should be filed within 12 months from the first filed application. A PCT application is an application that is filed in India as a receiving office under the PCT system. A PCT national phase application is when an international PCT application enters into the national stage process. This generally happens within 31 months from the first filing date or the priority date. Patent of addition. A patent of addition is an application filed for an improvement to an already existing patent application or to an already existing patent grant, wherein an patent in addition does not have the standalone to be a separate patent. Divisional application. An application which claims more than one invention, wherein the applicant or the patent office can divide the application into two separate applications. These are called divisional applications. With this, we come to the end of session 2, Introduction to the History and Origin of the Indian Patent System. See you all in the next session. Leave your comments or queries in the comment section. Subscribe to be a part of this video series for preparing for the Indian Patent Agent examination.